In grade school, she's always been, the leader. She's, she's usually the first honor or second honor growing up, and when she was in grade school back in the Philippines, and she's doing. Sometimes she can get A's and B's, so she's always been the smart one.
During her testimony, we learned a little more about the early years of Maya and Larry, about their wedding and their transition to the military life when Larry joined the military and was stationed out east, while Maya stayed with family. During her testimony, we also learned Maya liked to write, even writing a book. Mary Chris says she also kept a diary. Mary Chris is one of 25 witnesses that the prosecution expects to call. We've already heard from a forensic specialist who talked about finding possible evidence of blood in the home Larry shared with Maya and their 3 kids. But he emphasized the test could produce false positives and doesn't specify if it's human blood. Larry is accused of murdering Maya, who hasn't been seen in 2 years. This preliminary hearing is expected to last up to 3 weeks. Reporting from San Diego, I'm Marie Cornell.
Well, thank you to Chanley and Marie for those reports. Joining me now as our guest for this hour, Deputy Public Defender for LA County, Philip Dubé. Philip, always great to see you. Let's start first with Larry Millete, because we know it's day 2. We just heard about this, but this is a preliminary hearing. So remind our viewers what the purpose of a preliminary hearing is, and are you surprised that we are hearing all of the evidence and we're on day 2?
Oh, well, first of all, no, that's the whole purpose of we call it a prelim out here, preliminary hearing. A defendant has a right to get a snapshot of the evidence 10 days following his formal arraignment on a felony complaint. And what that means is the prosecution is obliged to put on a hearing before the court, just a judge without a jury, to prove probable cause to believe, A, that a crime has been committed, and B, that this defendant named in the complaint committed it. And absent that probable cause, the defendant wins a dismissal and release from custody. So what we have here is the defendant did not waive his right to a preliminary hearing, and the prosecution is going to go forward with witnesses. One of the things that he has going for him, Ashley, is in California, we have a rebuttable presumption in our evidence code that says that if a person basically hasn't materialized within 5 years of the last time they were seen or heard from, they are presumed deceased. But here, she's only been missing since 2021. I think they're going to be hard-pressed to even prove that they have a homicide. Just because somebody hasn't seen the girl since 2021, does not even rebuttably presume death. It just shows perhaps that she has disappeared. Additionally, I don't think there's going to be enough evidence to show that the blood found was a fatal amount. In other words, if they would have found a huge puddle or collection in the house, that would be a fatal loss of blood, almost like a hemorrhaging, if you will, then that's probably enough to show probable cause that a death has occurred. But we'll see.
All right, so let's talk a little bit more about this case, the preliminary hearing. It's not much evidence at all. I mean, the probable cause standard you just mentioned means if I were on the bench listening to this, there doesn't have to be, it's not a high burden that has to be met. And it's interesting because this case has something very similar to the case that we're covering in Jensen, and that is the sister testifying about what she was told from beyond the grave, assuming Maya is even deceased. Let's listen together.
All she said actually is just, be ready. It's going to be a messy divorce. She said, if something happens to me, it's going to be Larry.
Do you know when? Did she expand on that at all anymore?
No, because at that time, I was scared for her too. But I just told her, be careful.
Why would you say that?
Because I know Larry has that tendency to snap and be able to hurt her.
Philip, it's a little chilling to me that we have someone saying, she said if something happens to me, he did it. At the same time, in this preliminary hearing, we've been hearing that in Jensen, where she told lots of people, hey, if something happens to me, he did it. Is that evidence that you would expect would come in a trial in this case, assuming it makes it past the preliminary hearing?
Well, unfortunately, the United States Supreme Court decided this similar issue in Giles versus California that talks about the forfeiture by wrongdoing exception to the hearsay rule. And basically what it means is that if you have a hearsay declarant, in other words, an out-of-court person who made a statement regarding their potential loss of life in the future, and it states who they believe did it, and you can show that that person is now unavailable to testify and that they were killed to prevent that person from testifying, the statements come into evidence under the forfeiture by wrongdoing exception. Now, on the one hand here, you might have the fact that the woman may be deceased, assuming they can get past the probable cause standard, that you even have a homicide. But you're also going to have to show that the homicide was committed in order to get the statement in to prevent testimony. And I don't know what they're going to have to be able to show that other than perhaps a divorce proceeding, doesn't want her to take the stand regarding a custody dispute, distribution of community property assets, etc. So for now, I think it's a little premature to know whether or not those statements will come in at trial. Additionally, the forfeiture by wrongdoing exception has been interpreted to be a trial right. In other words, for purposes of due process and applicability of the rules of evidence at trial, the rules are a little different at the preliminary hearing stage, and the rules are pretty lax about allowing hearsay in.
Right, a lot of stuff comes in. I love talking to you about the law because you also pointed out the difference between this case in Jensen in terms of the reason for that statement being made and then the homicide resulting. So we don't know whether or not there's a homicide. We're going to stay tuned and continue covering that preliminary hearing.